Welcome. My name's Alicia Boardman and I'm from the IK Project Policy team at IP Australia. I'm here speaking to you from Ngunnawal land. I'm here with my co-host, Sarah.
Hi everyone, my name's Sarah. I'm a Wiradjuri woman, also currently on Ngunnawal land. I work in the trademark and design space as an Indigenous Knowledge examiner. I'd like to start off on behalf of myself and IP Australia to just acknowledge the Aboriginal Torres Strait Islander people of Australia and acknowledge the traditional custodians and the owners of the land on which our agency stands, which is the Ngunnawal people. IP Australia acknowledges Australian Aboriginal and Torres Strait Islander people's unique cultural and spiritual relationship to the land, waters and seas and their rich contribution to society. And we pay our respects to our ancestors and elders past, present and emerging, and we'd like to extend those respects out to the lands that you're dialing in from. Yeah, let's get started. So just to quickly go over what is IK, Indigenous Knowledge? IK is a term that we use to cover a range of knowledge held and continually developed by Aboriginal and Torres Strait Islander people. It can be language, song, dance, stories, songlines, art, and also things like knowledge of plants, science, medicines, and agriculture. And at IP Australia, we recognise the right of Indigenous people to their own knowledge with over 60,000 years of creative tradition. And for this reason, we are looking at ways that the IP system can better support Aboriginal and Torres Strait Islander people to benefit from and protect their Indigenous knowledge. Today, we'll be focusing on the current ways that the registered rights can be used to commercialise and protect Indigenous knowledge in your business. And as we go, we'll be asking questions, but also noting opportunities for better protection in the future. So today we're going to go through a little bit of a case study of Jess. So we're going to go on her brand development journey. This is a fictional case study that we've just come up with for this one. But if you are running a business, it's very likely that you have created your own IP. And in the Indigenous business sector, it's also likely that Indigenous knowledge has a place in your business. So using Jess, Jess has identified 4 potential IP assets, which use her traditional knowledge to try and help her gain a competitive advantage. She's going to start up a cosmetics business and she's going to utilise her traditional knowledge of a native bush grown on her country. So today we're going to be going through each of the IP rights that may be applicable to Jess's business, just as you would if you were starting any kind of business development.
So what is IP? Intellectual property is all about ideas and their ownership. It's about the rights of creators to make money from their own work. IP Australia is responsible for administering the registered IP rights. So that includes patents, which protect inventions, trademarks, which protect brands, designs, which protect the look of a product, and plant breeders' rights, which protect new plant varieties. Just to note, IP rights are territorial. So they're protected through national laws, which means that for each country you might like to trade in, you will need to register for your IP in that country. If this is of interest to you, there is helpful information on our website about how to launch your business internationally. So there's also unregistered rights that IP Australia isn't responsible for. We have copyright, which protects the owner's original expression of the idea, but not the idea themselves. And that can include drawings, art, literature, film, broadcasts, and computer programs. And copyright is automatic. So unlike the registered rights, you don't have to apply for it to have protection. There's also trade secrets. So any confidential information, including secret formulas or processes and methods used in production, can be covered by trade secrets. So for example, Coca-Cola has used trade secrets to keep its formula from becoming public for decades. There are other legal mechanisms to protect IK, as IP rights don't holistically protect IK. So just quickly, that can include contract law and non-disclosure agreements, which are existing mechanisms that you can use to share secret or confidential information, like your Indigenous knowledge, and ensure that it isn't disclosed to a third party. If you're bringing in new employees or working with business partners and you need to share your IK, an NDA could help you to protect that. Protocols can also be useful to establish standards and expectations around respecting IK. And to show that you are proactive in this space, You might also consider including an intellectual property page on your website and potentially a copyright statement at the bottom of each page on your website to demonstrate that you're active in protecting your IP and your IK. So let's dive into the registered rights. So back to our case study, Jess has an idea for a skin cream and she needs a way to differentiate her business in the cosmetic industry. So a way for her product to stand out in the marketplace and recognize her ancestry, which is important to her and a part of who she is. So she needs a trademark. A trademark identifies the particular goods or services of a trader as distinct from those of other traders. A trademark can be a logo, a word, letters, numbers, a colour, a slogan, a sound, scent, shape, a picture, or any combination of these. Registration lasts 10 years and it can be renewed indefinitely. So it's important to think about a trademark right at the start of your business journey. And trademarks are relatively inexpensive out of our 4 IP rights. They're around $200 to $400 depending on the type of application that you need. And really it's a small investment for the money and time that you can save down the track. We also have a fast track application process called TM Head Start. And TM Head Start allows you to speak with an examiner over the phone and get information on what might be an issue before formally applying. And you get that feedback within 5 days. A trademark is not a business name. This is often misunderstood. A business name and going to the to register for your business name is usually the first place that people start. But to demonstrate the difference, I'll just work through each type of business identity that we have here on the screen. So a business name, which is also known as a trading name, is the name under which your business operates and it's connected to your ABN. It helps your customers find, identify and connect with your business. A company name, very similar. It's commonly identified with proprietary limited. And if you want to trade using a name other than your registered company name, you should also register that trading name as a business name. A domain name is your street address on the internet. It's a way that people find your business online. Domain names are registered on a first come, first served basis. However, if a domain name is using a trademarked name, the owner of the trademark can take certain actions against you to recover their domain name. So that's a bit of a hint. Essentially, trademarks give owners exclusive legal rights to use the trademark throughout Australia. Unlike a business, company or domain name, a registered trademark lets you take action against other businesses using names that are the same or confusingly similar to your trademark. So the business name regulator does not check the trademark register before granting your business name. So it's a good idea to start first with your trademark on your brand development journey. So choosing a unique brand, what do we need to think about? Here at IP Australia, our trademarks examiners will be checking to see whether your trademark is registrable. And 2 key things that they look for is whether your trademark is unique and distinctive, and whether it's similar to marks that already exist. So what we mean by distinctiveness, so a trademark shouldn't be descriptive because another trader might have a genuine desire to use the word to explain to customers what their goods and services are.
For example, like we wouldn't allow soap on soap because other traders are going to need to be able to call their soap product soap without trying to infringe on any kind of branding.
And a trademark doesn't have to be as directly descriptive as that example. It could indicate a quality about your product. So it could be organic lotion or eco-friendly lotion, or include like the ingredient of a product. These are all kind of examples that don't directly describe the product, but would still be considered to be needed to use by other people in the ordinary course of their business. And so the other thing that we look at as well is whether your trademark is similar to other trademarks on the register. So this includes trademarks that are not exactly the same, but a little bit different. So it's important to look out for other images of a similar subject or design, spelling variations in your brand name, and things that sound the same. So our key tip here would be, at this point in your business brand development, to really do your research, get on Google, get on the trademarks register, and see whether the trademark that you're applying for is already being used. In our example here, Jess has actually chosen a word in her language, Biambul, which is the Wiradjuri word for all. And out of respect for her community, she spoke about using it in her business with her community and made sure it was appropriate and she had their consent before moving forward with her application. It's important to note that this isn't a requirement from IP Australia. However, through our consultations, we have gathered information that suggests that this is best practice. Another thing to note is about a right based on a language, is that when Jess gets the registration for Biambul, she will have rights to use the word to sell and market her product, but she won't have ownership over the word in all other industries, nor in non-commercial settings. A couple of things on trademarks, and I know this is a lot for people who haven't had a lot of exposure to it, but within trademarks, there's actually a couple of different types that can be useful for Indigenous knowledge and Indigenous businesses. One of them is a certification mark. So a certification mark indicates the goods and services that are certified by the owner of the mark and meet specific rules or standards that are associated with it. So a certification trademark can actually certify the quality, accuracy, or some other characteristic of the goods and services, including their origin or the material that they're made from or a mode of manufacture. So this is an option if you are wanting to look at communicating to consumers the authenticity of your product. Another type of trademark that we have is called a collective mark. And a collective mark is a sign used to identify the goods and services of members of an association and set them apart from goods and services that are provided from those who are not members of that association. Unlike certification trademarks, the use of a collective trademark is not required to be subject to rules. So it's a bit of a simpler application. A collective trademark can only be owned by an association and not by an individual or a proprietary company. So to apply for registration of a collective trademark, the association applying may be an incorporated or unincorporated body. But these types of trademarks may be of interest to Indigenous businesses or associations because they can recognise ownership beyond an individual, such as IK that's owned by a community. They could allow IK owners to retain ownership and control over their Indigenous names, signs and symbols. And they can be used to raise public awareness and maximise consumer certainty as to the authenticity or quality of the goods and services being marketed under that mark.
So at IP Australia, we do have Indigenous staff like myself and others that assist in identifying and examining marks that do contain IK, and we can pick up some inappropriate uses of IK in these marks, but we're really looking to strengthen these measures. And to do that, we need to know what you guys think are the things that are the biggest issues and that we should be trying to focus on and address.
So we're currently consulting with people to help ensure that the right people are using IK in trademarks, and we're looking at new checks in addition to the ones we've just discussed. So out of the three options, we are interested in which ones you guys out there think would be most useful. So out of the three options on the screen, which measure do you think that would be most useful to help with some of the issues surrounding use of IK in trademarks? Is it that the applicant has consent from the IK owners to use the IK? Is it that the use of the IK might be disrespectful or hurtful to the IK owners and we should be looking at that? Or whether you're concerned that consumers are seeing Indigenous knowledge in branding from businesses who aren't actually Indigenous?
Okay, so moving on in our IP rights journey, we're going to talk about design rights and what we mean when we say a design right at IP Australia. So here, a design right protects the overall appearance of a product, resulting from one or more of the visual features of that product. So what we mean by product is a thing that is actually manufactured or handmade, and the visual features refer to the shape, the pattern, or the configuration or ornamentation of that product. Those are the things you're getting protection for if you get a design right. Design right is a relatively short right. It lasts 5 years and it can be renewed up to 10 years, but it can be a very strong right if you use it correctly. So if we talk about Jess, you can see on the screen there's an image of a bottle and some packaging. That's actually 2 registrable design rights. The bottle can be registered and the packaging can be registered. So Jess wants her product to stand out on the shelf. And so amongst the other cosmetic lotions that she's making, so she comes up with the unique shape of the bottle and the unique packaging. And these are things that she can protect and get protection for with a design right. So at IP Australia, design rights, we have a 2-step system. So part 1 is registration and part 2 is certification. And once you do have a certified design right, you can enforce that and stop people using your design incorrectly. A design right is, as I mentioned, generally a short-term commercial asset, but it can be used as part of a wider IP strategy. One strategy you may like to consider is filing a design right up front to get that initial protection. And then as you build reputation in your brand, you can then look at maybe filing a shape trademark down the line to try and get that longer breadth of protection. Designs are relatively low cost. You should consider, again, like the part of it in your broader IP strategy and how that may affect. Generally, the costs are similar to trademarks. We do have filing costs at both steps, and enforcement can be costly if you did need to go to the courts to enforce something. One of the most important things about design rights is do not publish. When we're looking at whether or not we can certify a design right, what we do is we need to decide whether it's new and distinctive. And to do that, we search the internet to try and find if it existed before the filing date. So if we can find it anywhere on the internet before that filing date, you're going to end up with a problem getting an actual certified design right.
So Sarah, when you're talking about whether it's been published online, does that include even if I haven't made money from it or sold it yet?
Yeah, absolutely. If we can find it anywhere, even if it's just on your personal Facebook page, even if you haven't started selling it, you wanted to try and test the market before you apply for that, that's going to knock over your design right before you even start. So it really should be something you consider at the beginning of your business strategy as whether or not you're going to require a design right. And just to note quickly, there is an interaction between copyright and design, and it is very complex, and it does vary based on individual situations. Generally, if you are looking to commercialize a product, you would need to seriously consider that you may need a design right, as this can affect your copyright protections. As this is a highly complex and individualized situation, it's likely you may need independent legal advice. If you would like to know more about this copyright design overlap issue, please get in touch with us after the webinar and we can send out some information on that. So we do some checks in designs similar to what we were talking about with trademarks to see if it would be offensive to Indigenous people and whether or not that design that contains IK would mislead people if the source was not from an Indigenous business. So one of the questions we'd like to ask is, to help us identify IK in designs up front, should we be adding a requirement to the application form and process where applicants would have to declare that use of IK and where that permission was obtained from as at the filing stage of filing a design? So we'd just like to get your opinion on whether you think this is something that should be introduced with the design filing system. Okay, next up in our IP rights journey is patents. So a standard patent gives long-term protection and control over that invention. It lasts up for 20 years from the filing date of your application, or up to 25 years if it's a pharmaceutical substance. The invention claimed in a standard patent must be new or novel and involve an inventive step, and it has to be able to be made or used in an industry to gain protection from a patent. So if you do get a patent right, it will give you the right to stop others from manufacturing, using and selling your invention in Australia without your permission. It also gives you the ability to license someone else to manufacture your invention, or agreed terms to take legal action against people who are using your invention without your permission. It encourages Australians to continue their research to develop new and innovative products and exploit new technologies and promote the transfer of technology, throughout Australia. It also gives trading partners the incentive to provide similar rights and thereby protect our exports in a market overseas. So as far as Jess goes, as we've mentioned, she has a traditional knowledge about using her native flowering shrub that has medicinal use to try and treat skin problems. So Jess has used this knowledge and she's conducted further research and developed a new cosmetic which brightens skin. Jess could apply for a patent to protect a process for making a cosmetic or a plant extract from the native shrub. This patent could also be used to license and or earn royalties from other companies later down the track once she has established herself. Some of the key things to consider with patents are the costs, and there are a range of costs that should be considered. IP Australia's fees generally range from about like $400 to $500 for application and examination, but given that patents are complex and they take time and require technical or scientific specialties, you're likely going to need a patent attorney, and this is where things can get a bit costly. So there are a breakdown of fees, including attorney fees, IP Australia fees, and also renewal fees that you might want to look into. And you also are responsible for monitoring the market and enforcing your IP. And again, this is just for Australia. If you did want to try and look at extending that protection overseas, that's something you would have to look into as well. A professional can help you determine whether the time, effort, and money required to get and maintain a patent would be valuable for your particular invention. So it's worthwhile trying to get an opinion on that. As with designs, it's also really important to keep your invention or patent idea secret. You need to be aware that if you demonstrate, sell, or discuss your invention in public before filing an application with us, you may not get that patent right. If you do want to discuss something with employers or business partners, you can have them sign a confidentiality agreement. In particular, make sure you have an agreement in writing before you give away any kind of traditional knowledge. But yeah, it's really important. You should definitely consider talking to a professional to help you negotiate some kind of benefit sharing arrangement. The trade-off with patent protection is that you do make the invention publicly available. So protection also only lasts 20 years. So you need to consider, is patent protection right for you? Trade secrets, as we mentioned before, can also be another option that involve keeping your invention secret and can last indefinitely. It does involve having a process in place to keep the IK secret, and a trade secret doesn't require registration with IP Australia. As far as traditional knowledge goes, it's important to note that patent protection is only available for new inventions. So it can be difficult for some kind of traditional knowledge to meet this threshold in certain circumstances where they lack novelty because they've been around for a while. By the same token, if you think somebody has used your knowledge in a patent, there are ways to provide IP Australia with that information, and in some cases we can examine that and decide whether or not that may affect whether that patent is in fact valid. In most instances, trade secrets and non-disclosure agreements may be the best way to protect TK in a proactive kind of way.
Okay, so plant breeders' rights. These rights are used to protect new varieties of plants that are distinct, uniform, and stable. Plant breeders' rights are exclusive commercial rights for a registered variety of plant. If you've developed or are in the process of developing a new plant variety, protecting your IP through PBR should be considered an integral part of your overall business strategy. PBRs give you exclusive rights to produce or reproduce the plant material for commercial purposes or control who else can do so through licensing or similar arrangements. They offer the plant material, you can offer the plant material for sale and derive income from their sale either directly or through royalties. And this can include the harvested material like fruits and grains and not just the plants themselves. You can export the plant material to other countries and possibly protect it there as well. Again, this would require looking at applying for the rights in the other markets and in the other countries that you're looking to expand into. So what do we mean by new variety? It's one that has not been sold with the breeder's consent beyond the allowable time period. It must be distinct, uniform and stable so that when reproduced, it's true to type. So if you had knowledge of an endemic plant through traditional knowledge, that's not necessarily going to qualify for a PBR. So Jess, with her traditional knowledge and her booming cosmetics industry company, she has bred the plant to create a new variety that flowers all year round. Australian native plants, as we all are aware, are loved around the world, and given the medicinal properties of this plant, Jess decides to apply for a PBR. So once registered, she's got that PBR that can be used for 20 years of protection and commercial gain. It will allow Jess to control her variety and license others to grow it. She can commercialise the variety herself or through contractual arrangements such as licensing with a chosen person or organisation. She can possibly earn royalty income. For the protection period, she is the only one that can do this. It also gives other companies the confidence to enter into licensing contracts, knowing that their investment is protected. So this is just one way that Jess can commercialise her plant knowledge for herself or her community. When considering a PBR, it's important to consider the costs. So there are a number of fees involved. However, IP Australia's fees are staggered, so it gives you a bit of flexibility as you go through the process, as they're not all due up front, and they range from around $300 to $1,600. The main costs, though, are likely to be your QP fees and the cost of a trial. So a QP is a qualified person, and they're required to be engaged for each application. They're accredited by IP Australia to supervise growing trials and help verify the claims in your application. So the QPs will charge fees which vary from one to another, but that's independent of IP Australia. Different plans will require different types of trials, and the trial is essentially there just to establish that the claim is true and that the variety that you're applying for can be reproduced under the same conditions. It's important to be aware of timeframes with PBR. So there are different timeframes for different plant varieties in terms of how long you can sell the variety before you apply. So it's important to check the timeframes on our website so that you don't miss out. And whilst it's sounding quite complex, a PBR, it is simpler than it sounds. It can be for nurseries such as land council revegetation nurseries and even home gardeners. So we know, for example, that there's an Aboriginal owned nursery that have a PBR over the native plant Lamandra muru, and they've chosen a business model where they're not growing themselves actually, they're licensing that out and earning royalties from those established licenses. So it can be a bit of a long process with a PBR, but if you've got something that's worth it, don't give up. So in relation to plant breeders' rights and patents, we're proposing a new disclosure requirement where people would have to declare their use of IK and the source for genetic and the source of the IK, and for genetic resources to disclose their origin and how the genetic resource was obtained. This would be the first step in acknowledging First Nations people as the owners of traditional knowledge and recognising the role that traditional knowledge plays in informing Western science. The requirement could also help encourage conversations around collaboration and benefit sharing. So we're interested to hear from you out of the most important reason to have a new disclosure requirement, whether that would be encouraging honesty about the use of IK or deterring the misappropriation of IK. And if your IK was being used as a part of an invention or plant variety, how would you like to be acknowledged?
Okay, so that's a wrap on Jess's journey through the IP rights system. We've discussed trademarks, designs, patents, and plant breeders' rights. So just before we move on, let's recap 3 key things to remember about IP in your business plan. Number 1 is know your assets. IP rights don't holistically protect IK, but they can help. And it's important that you understand what your commercial advantage is and consider what mechanisms can best help you to make the most of your assets. A professional can help you develop an IP strategy for both your IP and also your IK and weigh up the costs and benefits to your business. The second one is size doesn't matter. Whether your business is large or small, an IP strategy is equally important. Good IP management can help small business grow into larger, more successful businesses. And the third one is proactive and informed choices are key to protecting your IP. It's important to be careful with social media or telling people about your business ideas before you have protection in place and before you really understand what that protection is. If we haven't covered in depth today, what we haven't covered is if you're planning on going overseas and doing business overseas, including manufacturing, consider international protection before you do enter into those markets.
So IP Australia, as we've mentioned, is looking at what more we can do to protect IK. And we've launched our consultations, which are open on 4 topics, which is establishing an Indigenous advisory panel, enhancing measures for trademarks and designs, declaring the source of IK in new innovations, and exploring interest in authenticity labelling. So to have your say and get involved with our consultations, just follow the link, which we'll also send out after the webinar.